Good afternoon, everyone. This is Rajiv S. Khanna from immigration.com, the law offices of Rajiv S. Khanna PC. This is our bi-weekly, every other Thursday phone call in which we discuss the questions posted by you. The answers are subject to the disclaimers you heard when you were logging into the conference call. Let me just confirm that you folks can hear me okay. Can you all hear me all right?
The conference is now in conversation mode.
Can you hear me okay, guys? Hello? Can you hear me? Hello? Can somebody say yes or no? I have no idea if people can hear me.
Yes, we can hear you.
Oh, okay, good. Thank you.
The conference is now in presentation mode.
Excellent. Let me just expand this a little if I can. Expand this a little. Okay, here we go. Let's begin first with the frequently asked questions, what I believe are frequently asked questions. First one is, how soon can I file for an H-1B transfer after joining? And do I need the employer's permission? So there really is no law that says you have to wait a certain number of days before you can apply for a transfer. Technically, you could start your H-1B today and transfer tomorrow. The only practical difficulty can be, government often says, if you are filing for a transfer, prove to us that you have been maintaining your status, which means you've been working and you've been getting paid for it. So some people would wait until the first paycheck. Often government expects 3, but if you have only worked there for, let's say, 2 weeks or 1 week, whatever your periodicity of payment is, then obviously you won't have 3 paychecks, and that's not needed. What is needed is that you worked for the duration of the transfer. Okay. Do you need your employer's permission? Absolutely not. You can change employers without the first employer's permission. There's absolutely no issue. Anyone has any follow-up question on this? Press *5. Any follow-up question? Press *5. Okay. There being none, let's move on to the next frequently asked question. Let us see. So this is another question that comes up quite frequently. Am I going to have problem during naturalization if I did not join my future green card employer and instead I continued working with my new employer? So the scenario is, it can work 2 ways. This scenario can work 2 ways. Let's say that your green card was started and filed by a future employer, somebody you've never worked for. And then the green card gets approved, but you're working for some other employer and you don't want to go back to this future employer, or you don't want to join. Then what happens? Second situation in which this arises is, you used to work for employer 1. They processed your green card to the I-140 stage. After that, you left and you joined employer 2. Now, your dates became current. You had a conversation with the old employer and they said, yes, we will still hold a position for you if you want to come back and join us. And you filed a form I-485 on those basis. Okay. Now the question is, what if my green card gets approved? Do I have to join that employer, employer 1? This is a complicated situation. Very difficult for me to give you bright line rules. First problem is, when you file the 485 with the job offer from the old employer or the future employer, the one that you're not working with, you're indicating to the government that you have the intention to join this employer upon approval of the green card. Now, if your I-485 stays pending for 180 or more days, you are well justified to file Form Supplement J and move your green card over to the current employer that you are working for, never joining the employer who sponsored your green card, whether it is the future or the past employer. That's the best case scenario. But what if your green card gets approved, your 485 gets approved before 180 days? That's when things get tricky. I can tell you in the order of safety what is best for you. First is to actually go and work for that employer on an indefinite basis, not just for a few days. When you go and join, you should have the good faith intention to continue working there indefinitely. But if in the next few weeks or few months you get a justifiably better job offer, I think you would be well within your rights to move. So join the employer if you can, number one. Number two level of safety is upon approval of your green card within a reasonable period of time, 3-4 months later, let's say, or up to 6 months, I'm just making a guess. Within a few months, you contact the employer who sponsored your green card, preferably via email, and say, look, I'm available to work, when should I join? Now, if that employer says, I'm sorry, we don't have a job for you, I think you are reasonably safe because you tried. Okay? So there are cases where this kind of situation, not exactly the same, but a situation arose where green card was approved, but the green card job was not available. The USCIS appellate authorities have held that's okay because the employee was willing to join the job. Okay, so that would be the second thing. Now the third thing I think is risky because now you've got the green card approval. It happened before 180 days passed and you don't want to join the old employer. I think that's risky. My understanding of the law as I see it so far makes me wonder what's going to happen at the naturalization stage. Government might say that, you got this green card in error. We are taking it back. So the questions that you have posed is, can I continue to work with my new employer using my green card? Yeah, you can. But like I said, you should join the other employer within a commercially reasonable time. And I have answered all of the questions that he has asked. So if there is a follow-up question on this, press *5. If you have a follow-up question, press *5. Okay, this is coming from area code 571. 571, where are you calling from?
Hey, I'm calling from Austin, Texas.
Austin,
and
Texas.
My name is Gopi Krishna.
Okay, Gopi.
Yep. Hey, thank you so much for doing this, and it's a great help to the community. So before, actually, I'm in exactly the same situation.
Right.
So I used to be with my past employer. They filed my EB-2
Right.
and I-140 got approved.
Right.
It was like 3 years ago.
Right.
Then I moved to a different company.
Sure.
So they filed my EB-3 485 last year.
Mm-hmm.
When dates were current, and obviously you know that later EB-3 went back.
Mm-hmm.
Now I'm trying to work with my current employer to file EB-2 I-140.
Right.
But in the meantime, surprisingly, they issued my green card, even without interfiling.
Yeah.
And at the same time, my past employer, they already offered a job, exactly 2 months ago before I got my green card.
Right.
So my question is if I go back to my past employer, I think USCIS, they used my past employer's EB-2 proactively,
Right.
and give the green card. That is my assumption. But
Right.
if I go back, my question is is it safe to go back? Yeah.
Well, let's look at your case. It's a little different than several other cases I've seen. They have approved many of these green cards.
Okay.
They're just trying to approve so many of them. Actually, I've just had one of our clients contact his congressman to make sure that USCIS gives us an answer definitively whether this approval is an error or not. I think it's an error, okay, because you're not working for that employer. So they cannot They cannot and should not approve that EB-2 green card. Now, the question is, should I go back and join them? So, I think so. I think if you go back and join them on an indefinite basis, I think you are fairly well protected. I think you are okay.
Gotcha.
All right.
Yeah, awesome. Thank you. Thank you so
You're
much.
welcome. Good luck, sir. Okay, let's see if there's another frequently asked question. Oh, yeah. PhD students and eligibility for EB-2 NIW, which is National Interest Waiver, working on F1 OPT. Is it possible to work and study in F1 OPT after completing the degree? Yeah, that you can do. I do not know of any law that stops you from doing that. So, is it possible for current PhD students to apply for NIW? Okay. So, yes, if you Google my name, Rajiv S. Khanna, or Khanna, as they say in the United States, the Economic Times, you will pull up my articles on the Economic Times. And one of them is applying for a green card while you're still on a student visa or student status. Okay? Keeping those in mind, can you apply for an EB-1A while you are still a student? Sure. EB-1B while you are still a student? Sure. National Interest Waiver? Sure. You can apply for any of these green cards while you are still a student. There's no law that says you've got to finish a specific degree before applying for any of these categories. Okay? NIW only requires a master's degree. It does require that you should have finished at least graduate education, which is post-bachelor's. If you have done that, you can qualify for NIW. So the answer to this question is yes. Both your questions is yes. Any follow-up questions on this, press *5, please. Any follow-up questions on this, press *5. Okay, then let me see if, here is another one. Yeah, this is another situation that arises unfortunately too frequently. So what happens if one gets divorced while the I-485 is pending? So the way USCIS interprets legal separation or divorce, it makes the derivatives ineligible to receive green card. So in other words, even a legal separation in the eyes of the USCIS is equivalent to a divorce or a marriage dissolution. So you can no longer get a green card through your spouse. Number one, what if you have used cross-chargeability? You are the primary and your wife was born in Nepal and you had used her country of birth. What happens? I do not know the answer to that question. I would have to have that researched. Obviously, cross-chargeability requires marriage to a person born in another country. But must the marriage subsist till the time of the green card approval? I would hazard a guess, yes, but that's no more than a guess. I haven't researched this issue. Okay. And the last question that you raised was, what if my wife then goes back to, for example, let's say India, and files criminal complaints against me under the dowry provisions of the Indian Penal Code? I believe it's called 498A. And we've gotten several approvals with 498As pending. But remember, each case is specific to its own facts. It's difficult to say how it will play out for you. But in the last year alone, we've gotten, I think, 3 485 approvals and 1 naturalization approval, while the 498A criminal complaints were still pending. So it's still possible to deal with it. It's nice not to have that problem. But if you have that problem, there may be a way to deal with it based upon at which stage your case is in India. Okay? So let's see. Can she harm my case by communicating with USCIS directly? Yeah, she could call them or she could write to them saying you're not entitled to cross-chargeability. And as I said, I'm not sure how that would play out. I would have to have that researched. *5 if you have a follow-up question on this. *5. Okay. I think those were the only frequently asked questions today. All right, now let's go back to the regular questions. We covered. Okay, now this is a very lengthy fact pattern. I usually don't have time to read so much information. But I believe that this is a conversation I've already had. So this posting may be old. In fact, I had a conversation about this today itself. So I'll just go over the scenario briefly and tell you what the choices are. So basically the idea is somebody is visiting the United States on a tourist visa. They have 6 months stay. They applied for an extension because of COVID. It's not safe to travel. They applied for an extension. Let's say 4 or 5 months after that, actually let me rephrase that. So let's say that they entered, they get 6 months stay. In the 3rd month, let's say they apply for an extension for 6 more months. In the 4th or 5th month, their package gets returned because of some technical difficulty, whether it is lack of proper fees or misdelivery. The package came back. Remember, you are still in your first 6 months. You sent the extension again, and now it is timely filed with the proper fees. So that makes your stay legal. But then you depart the United States after the expiration of your first 6 months, but before your extension could be decided. What happens then? Government says you are now subject to Section 222G of the Immigration and Nationality Act. What does 222G say? It says if somebody overstays their status, their visa is automatically cancelled. So your tourist visa, even though it was good for 9 more years or 10 more years, because you overstayed even by 1 day, became invalid or revoked. The problem is that's not the law. If you look at the policy enunciated by the US State Department in its standard operating procedures, it says that if somebody leaves before their extension is decided, we won't apply 222G to such people. But we are actually already struggling with one such case where the consulate has no idea what they are doing. We have pointed out to them they are wrong. Look at your own SOPs, and this is what your SOP says. They still say the same thing, copy paste, same response. So we've taken it upstairs. We've taken it to the review body within the State Department to see if they'll do something about it. What are your options? One is to fight it, like I just said, that this visa should not be revoked. And second is to just apply for a new visa, explaining the situation, what happened. And I think you will get it. The only problem is visa dates in some countries, including India, for tourist visas, etc., are about a year backed up. So at that point, you have no choice but to fight it and try to make the State Department, the Department of State, see its error. Because this is erroneous. If you leave before your extension is decided, you should not be getting 222G. Okay? *5 if you have a follow-up question on this. *5. All right. Go on to the next question. Can I start an LLC while in the US on an H-1B? I'm a software engineer, part-time day trader, want to open an LLC, want to grow my portfolio, not looking to withdraw any salary or money. I do not know if this is feasible or legal. Of course, if you wanted to start a side business, that would probably almost always be illegal. Now here, it could be argued that it's a single member LLC. I'm the only one operating it. It's basically me. I'm just not comfortable saying this is a clear-cut answer or there is a black and white situation here. Hard to say. Okay, I would probably not do it if I were you. *5 if you have a follow-up question. *5. Okay, now this gentleman or lady posted 5 questions. Okay, not just one, 5 questions. So I'm not going to answer all 5 of them. Please do not post more than 1 question. You can wait till the next conference call, or you can set up a consultation with us. We try to distribute a lot of our time with a lot of people, so I can't be answering 5 questions. First is EB-2 or EB-3, what is the right option? Does a green card depend on the country of birth? That is correct. It does not depend upon the country of citizenship. It depends upon the country of birth. If the country of birth is not India or China, is there any advantage of EB-2 over EB-3? Well, it depends upon the case. In some cases, if the job calls for a master's degree, of course, a lot fewer people would have master's degree than bachelor's degree. So in a practical perspective, it could help. But does it help in times moving faster or things getting faster? Probably not. If EB-2 and EB-3 dates are current, then whether you get EB-2 or EB-3 doesn't matter. It only becomes a problem if EB-3 dates slide back. Employment verification letter. What happens if the company or manager is no longer with the company while filing for I-140, changing jobs during the green card process? Or if the employer is no longer in business, does the USCIS reach out to managers and company to verify? Yeah, they can. For my green card, my attorney suggested me to use my master's degree because I earned the required credits before joining current position. I don't think that's how it should work. Because if your master's degree was finished after you joined the job, you will lose this case at the I-140 stage. Have your lawyer take a look at it again. Either your lawyer doesn't know what they are doing, or you are not quite clear about what they are doing. So I'll give you an example. Let's say I have not yet finished my master's degree. There are 3 credits left, or my thesis is left. And I joined the company as a software engineer. Now, 10 days later, I finished my thesis and I got my degree. Now, when I file for a green card requiring a master's degree, my green card will be denied at the I-140 stage, because when I took this job, the same job for which green card is being applied, when I took this job, I did not yet have a finished master's degree. And you cannot qualify for EB-2 either. So this labor certification would fail. I'm not going to answer the rest of your questions. There's a whole bunch of them. So I'm going to skip those. You have a lawyer, talk with them. If you wanted to get a second opinion, go ahead and reach us for a consultation. Or you can wait till the next conference call and add them there. So next question, actually star 5 if anybody has a follow-up question on what I just discussed, which is filing for a labor certification, etc., PALM application. Okay, so what happens if I apply for my 10-year green card renewal? I do not have any criminal record, always paid my taxes, but can they deny my renewal for failing or forgetting to file an AR-11? Well, you only forgot it once. I don't think that's going to be a problem. And the government doesn't look at AR-11s, etc. When they renew these green cards. So have I ever heard of anybody getting a green card renewal denied because of failure to file AR-11? No, I have not. Okay. Failing to file an AR-11 is I don't know if it is a deportable offense. Let me try to remember. Yeah, but it's a misdemeanor. It can be a problem. So I have never heard of anybody getting into trouble because they forgot to file. Well, hang on one second. We have a lot of people logging in. I'm going to lock the conference because pretty soon we'll be dealing with new questions. Maybe I'll wait another couple of minutes. So I don't think people get into trouble for not filing AR-11 just once, personally. Okay? So on the books, you could, but as a practical matter, I doubt it. Star 5, if you have a follow-up question. Star 5. Okay. Next question is, can I work on H-1B with an approved EB-2 and stay in Canada while my spouse is on TN, children are on TD? Sure, why not? You can. I don't see any problem with that. I'm a Canadian citizen working on H-1B. I have an approved I-140 EB-2. Wife is on TN, kids are on TD. My company started a Canadian subsidiary. Now the company is willing to do an intra-company transfer to Canada for a period of 12 months as a technical manager. After 12 months, my company is willing to do intra-company transfer. So in principle, all of that looks okay. All right, but I would double check on the remote position. That's the part that I am a little hesitant to say yay or nay to. But if you are doing a job locally in Canada, there's no doubt you can do it. I don't see any problem. So your questions are, return to US on TD visa under my wife? Yes, you can. And perform remote role from USA for the Canadian subsidiary? Yeah, you could. And this is a little complicated, okay? So I'll just give you briefly in one line. To qualify for an L1A or an EB-1C green card, you could be managing employees or operations in another country as long as the operations in USA and operations in that other country are part of a single operation. Okay? So for example, let's say we manufacture some sensors in Canada, but we put chassis on them and do the sales from USA, then it's part of the same operation even though it's two separate companies. Okay? But your lawyer should definitely look at this issue that you are trying to qualify if you are working from Canada remotely on a US operation. Does that qualify as foreign occupation or occupation abroad? That's something that should be looked at. I do remember doing a few cases like this, but they can be tricky. Just make sure that angle is looked at. The rest of it is okay. *5 if you have a follow-up question on this. *5. Okay. Let's go on to the next question. Oh, guys, you gotta be a little quicker than that, right? Area code 510. 510, are you calling from California?
Yes, sir.
Okay, sir.
Hi.
Go ahead with your question.
Hi, Rajiv.
Mm-hmm.
Yeah, the question is, they have, the thing is, if everything is okay, then I can come back to US on TD visa and then I can still work for the Canadian operations, right? Is that something legally allowed?
If
Then
you are
again,
on,
when I come back,
if you, no, not on TD, on L1A. You should come back on L1A if you qualify.
Okay, all I'm trying to say is the first 1 year, maybe 2 months I spend in Canada and then I come back to US and then TD, I work after 1 year, I will go back.
Yeah, I'm a little hesitant to say that's going to be okay. Because basically some of the benefits, there are connections between the US and the Canadian company, and what you are doing is you are working on US soil. So indirectly you are actually also involved in unauthorized employment because there's a connection between the Canadian and the US company. So I would be hesitant to say that's okay. So you should have a work authorization.
How about if it's a short term?
Sorry?
Yeah, so, okay. But,
yeah.
But I can always come for a short term visit to see my family.
Oh, that's never a problem. That's never a problem. But remember one thing, if you come and visit the United States, make sure that you spend the same number of days outside. So if you come for 10 days, you will need to spend 1 year and 10 days outside to qualify for L1. Okay?
Oh, okay. So that is a dependency of the 12 months.
Yep.
Okay.
Good luck.
Okay. Thank you.
You're welcome, sir.
Thank you.
All right. Bye-bye. Okay, let's go on to the next question. Oh, I have to lock the conference. Give me 1 second.
The conference is now locked.
Yeah, we're coming to the point we'll be doing new questions. So N400, ongoing residence and physical occupancy. You mean physical presence, I think. My parents were out of the country on advance parole when their green card was issued. Date of departure is September 7th, 2017. Green card issued 1 month later, October 20th. Date of return to the United States, April 24th. Well, so you are trying to figure out when is the first day counted for the 5-year requirement. So look, first of all, the date the green card is approved is the date they start counting absence from the United States from. Okay. So if in any 1 year, 12-month period, they're outside USA for more than 180 days, they have to have an explanation. Okay. So it's not 165, it's less than 180, you are okay. So the green card was approved, let's say October 20th. They came back on April 24th. So how much does that make it? I think it's more than 180 days. So October, November, December, January, February, March, April. I think it's beginning to look like more than 6 months. So I think you would be better off starting your 5 years if you don't have a good explanation. Start your 5 years, or actually even 4 years one day. Just start 5 years, easiest thing to do. And think that you will be filing naturalization in April 2023. That might be the safest thing to do in my opinion. Okay? Yeah, and you can submit 90 days before April 2023. So 90 days before April 2023 should be okay. And you already calculated that. Yes, good. Excellent. Yeah, Chirag, I agree with you. This is the right approach. Take it from 5 years from there. Although there is a 4-year 1-day rule also, I would rather not get into all those. I would just do a complete 5 years and get that done. Okay. *5 if you have a follow-up question. Press *5. Okay. That's from area code 646. 646, where are you calling from?
Yeah, I'm calling from Connecticut. This is Chirag, and thanks for taking my question. I appreciate the clarity.
Absolutely.
Thank you.
You're welcome, sir. Bye-bye.
Bye.
Okay. Anyone has any question, press *5. Anyone has any question, please press *5. Okay. So we have 6 questions so far. 6 people have questions. I'm going to go in the order that you logged into the system. So let's start with Arkansas, which is area code 479. 1 second, I screwed that up. Let's see. Okay, I can hear you, Arkansas. Go ahead. 479, go ahead.
Hello, Rajiv. Thanks for taking this call.
Of course.
I think I asked this question, but wanted to double check or maybe get better clarity.
All right.
So 485 EB3 applied in EB3.
Mm-hmm.
USCIS approved the 485 in EB2.
Mm-hmm.
PD is not, priority date is not current in EB2, but
Right.
priority date is not current in EB3, but it was current in EB2.
Right.
Without me doing anything,
Right.
did they pull up my old I-140 from previous employer that was EB2 and just gave me a green card?
Yeah. You are probably the 25th person I've heard this story from. One of our own clients has the same issue. So what I told him was, contact your congressman. Although you can file a form I-90 for a green card replacement, you can for government error, you can even open a service request. But I think the easiest thing and the best thing and the fastest thing and the freest thing is to just contact your congressman, tell them you're not sure this green card has been approved appropriately because you were not with that employer. The government should put you back into 485 waiting status. Okay? Contact your congressman. That's the smart thing to do.
So you think that it's an error?
Absolutely.
They issued this green card?
I think it is an error. Yes, sir. Okay, second option.
What if USS does not respond to the report?
Oh, if congressmen, they always respond. And by the way, another thing I suggested to somebody else today only was if you want to go join that employer, that's okay then. You know, whichever employer I-140 was approved, if you can go join them and continue to work there for an unlimited amount of time, unless you get a much better job offer somewhere else, you should join them in good faith, and then you should be able to keep that green card because you joined that job. Okay? Make sense?
Okay. So one last thing, sir. So you are saying that it's in error. So should I be using the green card or should I be handing it off to you?
I already told you what to do. I told you to contact your congressman's office. Ask them to find out from the US.
Thank you, sir.
Yep, that's what you should be doing. Good luck. Okay, then I go on to Maryland, area code 443. Maryland, I can hear you. Go ahead, please. Area code 443.
Good morning. Good afternoon, Mr. Rajiv.
Yes, ma'am.
Yes, I am a U.S. citizen. I am here only for a short visit, visiting my sister. I never live or work here because I work in the Philippines. Now I'm planning to move here after I give birth.
Okay.
I'm planning to give birth in the U.S., in the foreign country, in the Philippines, because my husband is a non-U.S. citizen.
Okay.
Now my concern is, how can I bring my child with me when I move here after giving birth for good?
Okay.
Can my child have apply for a U.S. passport?
Okay. So you have to look at two things, and I'm just speaking from memory. One is that if a child is under the age of 2, okay, you can always bring them back very easily. That is not a problem. And then when they get here, look at the instructions on the form N600. I don't remember exactly what the requirements are. There are two possibilities. Either you will come into the United States and apply for a green card for the child, or the child is automatically eligible for naturalization because of your citizenship. One of the two is possible. You should be able to figure out from the N600 instructions. Okay?
N600.
Yes, N as in Nancy.
I just go to the website,
Yeah.
N600.
Right, N as in Nancy.
Okay. Because I plan to move out as soon.
Right.
Sorry.
Right. No, that would work. That would work, and congratulations.
Yeah, I'm planning to move out here to come back here for good.
Yes, ma'am.
Because I want to petition my husband after that.
Right.
So I'm planning to come back here.
Ma'am, I also
after giving birth. So
I also want to add something for your knowledge. You can apply for your husband even though you are living in Philippines. So you can apply right now if you want. Okay? You can apply for your husband.
So even I never work or live here in the
Okay,
US.
hang on.
I can do
Hang
that.
on. You can. The only law is, the law says, when it is time for him to interview for his green card, you should already have moved back, or you should be in the process of moving back.
Yes, sir.
Okay.
Yeah, that's our plan.
Yeah.
The only concern is my child. I don't want to leave him or her behind.
Oh, no.
I was just,
That's
make
not.
sure that I can apply at the embassy.
Yeah, that's not a problem. You can contact the consulate. I don't remember exactly what the procedure is, but a child under 2 is absolutely no problem.
Yes, sir.
Okay?
Oh, great. Thank you so much. That's giving peace of mind. Thank you, attorney.
You are welcome, ma'am. My name is Rajiv. Bye-bye.
Okay. Mr. Attorney Rajiv, I'm so sorry. I'm sorry. Thank you so much.
You're welcome. No problem. Good luck, ma'am. Okay, let's go to the next question, which is from New Jersey, area code 862, I think. 862, I can hear you, please. Go ahead.
Hey, Rajiv. This is from New Jersey.
Yes, sir.
So, first of all, thank you for this call that you do every bite.
Absolutely.
And my question is, so I'm currently on F1. So I'm on my post-completion OPT. My EAD card that has expired. I've filed as 7C.
Okay. Hang on. Your voice is moving in and out.
I've got.
Yeah, I can't hear you that well. Could you either move closer to whatever your speaking device is and try to speak a little slowly. So all I heard was you are on OPT and you are an F1 student. What happens next? Tell me the rest of the story.
Yeah. So I have applied for STEM extension.
Okay.
I have received 797C.
Okay.
Okay. My EAD has expired.
Okay.
Right. But I want to travel on a Alaskan cruise which has an international port.
Okay.
Right. So I have to re-enter US again.
Okay. Actually,
is it possible to re-enter?
Hang on 1 second. Do you currently have a F1 visa that's not expired?
Yes.
Okay. Are you
I have F1 visa that is.
Are you at a computer right now?
Yeah.
Okay. So, in your browser, go to our website, immigration.com. Okay. Go to immigration.com, and on the very top panel, you should see a link to my blogs.
Okay.
Okay. Now, let's see. Interestingly, when you go to my blogs, go to page 3 of the blogs. I can't open the. I'm actually on another system.
Yeah.
So just go to.
Third link. There is F1 students travel during.
Exactly. That's what you need to read. Okay.
Yeah.
Just read that up.
Okay.
And you should be fine.
Okay. Do not travel. Okay.
All right. So whatever that says, because I sat down,
so
I figured out all the regulations that apply at various stages when you are on OPT, pending STEM OPT, pending H1B, approved H1B. So I figured out all those and put them in an info map. So whatever that says, that's what you need to do. Okay.
Okay. Thank you so much.
You're welcome. Okay, let's. This one is California, area code 310. California, I can hear you. Go ahead, please.
Yeah, hi, sir. This is Vinod.
Yes, Vinod. Hello.
Hello.
I can hear you, sir. Go ahead.
Yeah. Hi. So, thank you. So actually, the thing is like my priority date is 2014 March 20th.
Right.
And my both the files like EB-3 downgraded in 2020 that is moved to NBC, and I have refiled EB-2 in June 3rd 2022, and my fingerprinting were applied from EB-3 to EB-2, and the files are both in NBC.
Okay.
So, but I have received 485, 765, and I-31 copies, but I have not received 485J.
What do you mean?
So is it a concern?
Hang on. What do you mean you have not received? You mean you haven't received the receipts? Is that what you're saying?
No, I have received the 485, 765, and I-131 copies, but I have not received I-485J.
Okay, what do you mean you have received copies? Copies from whom?
Like UCIS, I have received the receipts.
Oh,
from
so
the
yes,
USCIS.
that's exactly what I'm asking you. I'm asking you, are you talking about receipts? So yes, if you have not received the 485J receipt, I'm not sure what the times right now are. You can check with your lawyers, they should know. But I think receipts are getting delayed quite a bit. Okay, so
Okay.
I won't be
And
surprised.
the second question is how much chances I have to be getting my GC by September 31st?
I don't know. That's so difficult to say. I only can tell you this, that they are trying to approve as many cases as they can, and some of them are being approved by mistake also, as you saw today. So I can't really predict that. Sorry. Okay.
Yeah.
Good luck.
So last question on 485J. If I don't receive that in next 1 month or something, do I need to contact the UCIS
You need
for
to
that?
you need to contact your lawyers to ask them what is the normal time for supplement J receipts. I can't tell you, our office would know, rest of the team would know, but I don't keep track of that level of detail. I don't remember. So check with your lawyers what the normal time is. Okay? Good luck.
Okay. Thank you, sir. Thank you very
welcome,
much.
sir. Bye-bye.
Thank you, sir.
My pleasure, sir. Okay, let's go on to the second last call. Also from California. No, this is from Florida. Florida, go ahead, please. I can hear you. Florida.
Hi, Rajiv, sir. How are you?
I am okay,
thank
sir.
You for...
Go ahead. Go ahead with your question. Hello. We lost you. Hello.
Yeah. Hello. Can you hear me, sir?
Yes, I can hear you, sir. Go ahead.
Hello.
I can hear you.
Okay, sir.
Go ahead.
Thank you for the opportunity, sir.
Of course.
Okay. The thing is, I moved to United States in 2015 on H-1B, and in 2021 last year I got married to a U.S. citizen.
Okay.
And we came down in May. We got married, and in September we came to India to attend one of my sister's wedding.
Okay.
What happened was I needed a stamping. I did have a valid visa till November 2023.
Okay.
Valid I-197.
Okay.
I applied for stamping. However, it has taken 10 months. Still the stamping request is in administrative processing. And my wife, who is a U.S. citizen, she and we also have a kid. So all three of us are stuck here. So what is that we should be doing?
I think you should also apply for your green card. Check with the consulate, because there is a USCIS office there. I think it's in New Delhi. But you can check with the consulate.
New Delhi, yes.
Yeah, because you might be able to get an I-130 approval relatively quickly, and might as well start your green card process as well. It doesn't hurt your H-1B. It just gives you one more option. Okay.
Okay. So it is not necessary that I should come back to US and apply, right?
No, you can apply from there, as far as I know. Double check with the consulate what the requirements are. Actually, the consulate will refer you to the USCIS. I think they share the switchboard. Just check with them whatever is needed. Apply for an I-130 right there. Okay. Are you all right, sir? I think we lost you again. Okay. Well, raise your hand again if you... Yeah, okay, you got it.
Thank you.
You're welcome. Good luck. Okay, and the last question we have today is from Ohio. Ohio, I can hear you. Please go ahead.
Thank you, Rajiv, sir. Thanks for taking my call.
My pleasure.
I joined an employer in H-1B visa, and I had an EB-2 I-140 approved in 2012. When EB-3 became correct in 2021, I applied for the EB-3 I-140 485 using the 2012 form. Today my period is current only in EB-3. I retrogressed in EB-3, and I didn't apply for EB-3 to EB-2 upgrade. Still, GC is approved yesterday with 485J approved. Not sure if it is an EB-2 or EB-3.
Yeah, see...
Since I didn't get my GC in hand.
I'll tell you something. Hang on. Your case might be a little different because if last month your dates were current, it is possible that the government, USCIS, got your visa number last month, but they approved your case this month. That can happen. So the process of green card works like this. When your 485 is adjudicated, they don't send you a notice yet. They contact the State Department for a visa number. They do it over fax or email. So let's say at the end of the month they approved your case, then they asked for visa number, they got the visa number, and then by that time next month arrived and your date slipped back. They can still issue you a green card because they already had you approved last month. Got it?
Sir, yes, sir. But my question is, it was not current in last month.
Okay. So if it was not current, then do what I just told another gentleman. Contact your congressman's office. Have them confirm with the government that this is not approved in error. Because you want to fix it right now if it is error. Okay?
Sir, this is if it is approved in EB3. What if they approved it in EB2?
I don't know your whole case. That is something your lawyer should discuss with you. But if you feel there is an error in your green card, even if you have a little bit of doubt, contact your congressman, have them confirm it with the USCIS. Okay?
Okay, sir. Just one follow-up question. So suppose thinking that the GC is valid, and say how soon I can leave the employer? I've been with them for last 12
that's in
years.
our frequently asked
I-140
questions. That's in our frequently asked questions. Read up. It's a lengthy answer. Okay. Good luck.
Okay. Thank you.
You're welcome. Okay. I think Florida has a follow-up. Florida, go ahead.
Sorry, sir. I forgot to mention one information. As I said, you asked me to reach out to USCIS. My employer also filed my green card on EB-2 in 2017. My current
hang on.
date is
Remind me.
2018 Feb.
Remind me. Are you the guy stuck in India? Who are you?
Yes, that's right, sir.
With the U.S. citizen spouse and a child?
I'm the guy who's stuck in India. Me and my wife and my kids.
Right. Okay. So the fact that your employer has also started a green card doesn't matter at all. You can have a green card going in 10 categories if you want. No problem. Okay?
Perfect. No problem. One follow-up question, sir. Can I also take up a job in India while I have...
What are you supposed to do? Absolutely. What are you supposed to do? Starve? Absolutely. Take up a job. No problem.
Okay.
All right.
Thank you. Thank you so much.
You're welcome.
Thank you. Thanks.
You are very welcome, sir. Well, folks, it's good talking to you. I will speak again in 2 weeks, next to next Thursday. And it's a pleasure hanging out with you. Take care, everyone. Bye-bye.